Hey, how's everyone doing? I'm Alvaro from the Novo Agency, and something that we're trying to do right now is have conversations with experts within the music industry to get a better idea as to how to navigate the music industry as an independent artist. It can be very intimidating. I like to tell artists these days that you need to be you're the songwriter, but then also the manager and the lawyer and a whole bunch of other things. And sometimes there's no one there to teach you. So today we're going to be meeting with Ryan Smith, who's here on the call, who's going to be helping us figure out some things when it comes to what a lawyer does in the music industry, what kind of things you should know when working with a lawyer, or things that you should do on your own. Ryan, how you doing?
I'm doing well. Thanks for having me.
Okay, awesome. Yeah. As we met a couple of weeks ago, I believe, you contacted us, you wanted to speak, and then, we figure out that you have some amazing content when it comes to the legal side of the music industry. So I think the first question I could ask you is, to those who have too much of a general idea when it comes to it, what specifically can a lawyer do for me as an artist?
Excellent question. So I get that question every single day. People want to know, what does a music lawyer do? What does an entertainment attorney do? And what can they do for my career? My answer is always legal work. There's a lot of misconceptions about entertainment attorneys that go out and find you deals. That's really the job of your agent, of your manager. Where we usually get involved is when somebody has approached you with a deal. If there is a contract that somebody's giving you that's trying to hold you down to some specific deal for multiple years, that's a perfect time to go talk to a lawyer. But if you're just starting out and you're just starting to make your first little bit of money in the music business, it's also not a bad idea to talk to a lawyer about setting up an LLC or your actual entity.
Okay, so that's, I feel like, two topics that I really, really want to go into. The first one is, these deals, because that's something a lot of artists, when they're starting to develop their career, can be very afraid of. Because personally, as in my time working in the music industry, I have seen artists pick up the wrong deal and just get horribly screwed over. And it's obviously when someone is giving you these deals, they're gonna throw a bunch of roses on them and tell you how amazing this deal is. But in your experience, what would be some particular red flags that come up first when you see a bad deal?
One of the first things I think about a red flag with the deal is if anybody says to you, don't have a lawyer look at this. That should immediately raise a red flag. If somebody's trying to convince you, no, I promise you this is a good deal, this is all standard, probably means the opposite is true. It's a terrible deal and they're trying to screw you over. Mm-hmm. Another related thing is if there's a lot of pressure to sign a deal really fast. Mm-hmm. Just about no deal I know of is really this life or death, sign it within the next 24 hours or this deal goes away. If anybody is giving you that type of pressure tactics in the beginning of your working relationship, you have to really consider whether or not this is going to be a good fit for you. And then some other things that might not be as obvious. When you look at how long this contract's going to be, it's also known as the term in a contract. Artists might think that a longer term is good for them. They might think, wow, this label, this manager, this publisher really believes in me and wants to have this long-term relationship with me. But that kills your leveraging power as an artist, because what happens if they've got you locked down for 10 years, you're this new artist that doesn't have a lot of clout and hits under your belt, but in year 8 you really start picking up. If you were under like a year-to-year deal, you could have leveraged that hit to then get a bigger and better deal. But if you're in this long-term deal, you've already signed away all those rights in year 1.
Too long, that makes sense. Right now there's a case I find very interesting. Paramore, the amazing rock band, they had like a 20-year long year deal with Atlantic Records. It recently, finished, and now the band is like kind of scrambling to see what's next for them. I think it can be an opportunity for amazing things, but it can also, if they don't manage this properly, it can be very dangerous. But I wanted to ask, you say a year-by-year contract, that seems like a good idea. Is there anything you would consider too short? Or at what point would you consider this is officially too long?
All of it's going to depend on the actual deal, on the actual people. Like if you've got a really good sense of somebody They're very legitimate. They're offering you the world. They're going to pay you well. They're going to respect you. They're going to let you have creative control. Maybe a little bit longer deal is okay. Oftentimes, however, you see people that aren't the most legitimate that are really more concerned about locking you down so nobody else can have you. As far as like how short a deal can be and how long a deal can be, I mean, it can be as short as this is this song only, and we are just going to work this one single or this one demo from the time that you release it and for the next 6 months or something like that. That can be as short as a deal can be. Or it can be, this is going to be, we're going to do one album cycle, but we're going to have the option to pick you up for another 3 options. And what that really means is that the label has the unilateral sole right to pick you up. If you're doing really well, they get to choose if they want to keep working with you, but you don't have that same right to say, I don't want to keep working with you. You know, you're stuck and they have all the power.
So you got to break up with me, I don't get to break up with you.
Exactly.
Very relationship-y language there, but yeah, it seems like it makes sense.
Yeah, because you think about this. A contract can be the most beautiful, artist-friendly deal that's ever existed. You know, a lawyer like me could put together the best deal that you could ever ask for. And that isn't going to mean anything if the party on the other side doesn't live up to those promises. So at the end of the day, it comes down to the people.
It comes down to the people. Now, when it comes to those promises, I assume that's where a lawyer can be really helpful, because it can help you really digest what are these promises being made, what are the consequences if they start to slack off when it comes to these promises.
Absolutely. I mean, really, when you look at what a contract is, it's just a series of different promises. I'm going to pay you. In return, you're going to give me 10 songs and you're going to promote these songs, and I'm going to do this X, Y, and Z. I'm going to put you on tour. I'm going to do a whole Spotify marketing push. I'm going to do a radio tour, and you're going to write music and perform it. At its most basic, contracts are just a series of different promises.
Okay, awesome. So this next thing you spoke about, which is, it's something relatively new to me. It was suggested to me when I released my first album. I didn't do it because I wasn't just not getting the money in, but you were talking about registering your band or yourself as an artist as an LLC. And many artists, you know, including myself back in the day, were very, very skeptical about this. What constitutes, you know, having your band as an LLC? What are the benefits? When do you think an artist should do it?
If you are making any type of money for your band or as your solo artist project and you're spending money, you need a business ASAP. An LLC is going to be the cheapest insurance you've ever bought for yourself for your music and your taxes. And I'll explain that. It used to be that you would have to file like a C corporation, and those can be expensive. They can be tricky to run. You have to elect a board of directors. You have to hold annual meetings. You have to have shareholders. But that all changed in the early 90s when this LLC really took off. And it is a very cheap entity to set up. It's very easy to set up. There's minimal operating costs each year. Once you do set it up, you just have to pay an annual filing fee with your state. And you also have a lot of flexibility. How do you want to be taxed? If you are an individual, you can be taxed as a sole proprietorship, which has a lot of benefits. If you're a partnership, if you have more than 2 owners, you can be taxed as a partnership. And it really just is going to depend on what your goals are. But unlike you just earning money as a solo musician without an entity, you now have a business, an EIN, a business bank account, which means that all of the expenses that you pay for your music are now tax deductible. It's not just that all the money you make is just income and everything you paid, too bad. This is now legitimate business expenses. And I'm not a CPA, I'm not an accountant, but they will back me up here. Go talk to them. The numbers don't lie. You can save a lot of money as an artist by simply having an LLC set up. Now, there's also a liability protection in place too with this LLC. LLCs in the entertainment industry are usually known as loan-out companies or furnishing companies, which means that they are the business that contracts for you. They furnish your services. So if you're signing a record deal, it'll be your record deal, your record company, LLC, for the services of you, the artist. And what that does is that limits your personal liability. So if there was ever anything that went wrong in that deal, they're not going after your personal car, your house, your personal money. They're going after the assets of the business. Now, the only time where that doesn't always apply is in that personal services category. Like if I'm signing to a record label, they want me to be the artist to perform. You know, they don't want some company performing. So like I will still have to go to the studio and record, and I can potentially be held liable for copyright infringement if I stole somebody's song and recorded it. But all of the other things that might come up, just simple breach of contract, that's all going to go to the business. So between those two things, tax benefits, personal liability protection, it's really, really cheap insurance, and you should do it.
Every time I speak to artists, I tell them, you're creative, you're an artist, your music is like sacred. But whenever you're done writing music, that's when you start being a businessman. A business person. That's when you need to figure out how am I going to turn this product I just made into, making money off of it. And that's where a lot of musicians, myself included, back in the day, really struggle. But as much as I say this a lot, this is a side that I never really thought about that much, all that, actually registering it as a business. I'm not like a life coach just telling you what to do. No, there's an actual, legal process that you have to go through and, all that stuff, which I think is very, very interesting. There's a story I want to tell you that I heard from a music industry lawyer back in the day that I wanted to see what you think about this. Does it make sense to you? Who do you think messed up here? Because there's an artist here where I live in Mexico that I'm not going to say their name, obviously, because I don't know what liabilities would come with me actually saying their name. But the name of the artist was a very generic word. It was just a single word that you can find out of any dictionary, okay? And they never registered the band's name because they were like, oh my God, it's just a very simple word. No one can, take care of it, take charge of this word, And then they were about to play a very big music festival when they get a call, like 30 minutes before they get on stage. Someone said, I just registered that name. If you play that concert under the name that is mine now, I will sue you. And it was a mess with the lawyers. That person was obviously, trying to get some money out of this whole situation. What do you make of the story?
Okay, so I can't speak to what differences may exist in Mexican law and United States law, but a lot of the concepts of intellectual property are very much the same because there's a lot of international treaties that honor intellectual property laws throughout the world. So a lot of times these deals are very much the same. So my take on this is a trademark issue, right?
Yeah.
The rights that you have in a trademark, even before you file for that federal trademark protection, are only going to be so strong as how strong that type of mark or name is, right? So if something is generic, it's going to be a lot less of a strong name. So like say, I can't register cheeseburger for my cheeseburger company because that just describes, it's descriptive and it's generic of what a cheeseburger is, right? But if I like say something like arbitrary, like that doesn't make any sense as far as cheeseburgers go, if I say like pineapple cheeseburger or like avalanche cheeseburger, probably even better, then that has no connection. That's kind of arbitrary. So if people start to associate me as the owner of Avalanche and I make these burgers, then I've created some rights. Now, even further from that is just completely made up, like, fanciful words where like, like Kodak is one of the best brand names of all time because it was just a made up word. They completely owned that word because it didn't exist. Pepsi is a word that just didn't exist before, and they 100% own that. So the more that you get into a place where you make up something, the stronger your rights are going to be. As far as your exact example, if this band was pretty popular and they were using this name that maybe not had the strongest of names, but people were associating that name with them, they could have actually gained enough goodwill in that name as that they are the source of that name, that more people that you talk to than not think of them when they think of that name. And, you know, whether or not you actually went and filed, there are some rules on who's first to file and whatever. But another requirement of trademark is that you're actually using it in good faith in commerce. So if this person just filed to just be this intellectual property pirate and try to troll some people out of a settlement, those protections aren't going to be very good, because you have to stack what their rights are versus the rights of this band that is probably making a lot of money and selling a lot of merchandise using that name. It sounds like a cash grab. We saw something kind of similar with when Lady Antebellum changed her name to Lady A, and there was this jazz singer who had been going by Lady A for years and years. It can get messy, but it's often resolved with some type of settlement because it's just not worth fighting over.
Okay, totally. That's something that I've heard that a lot of legal issues in the music industry end up resolving in, is people realizing, hey, maybe this is just not worth fighting into, and it just gets resolved out of court. That's something I've seen a lot.
Yeah, absolutely. It's always going to be in your best interest to resolve something without going to court, because that can be incredibly expensive.
Yeah, and I bet emotionally exhausting and just unpleasant.
Oh, absolutely. I mean, litigation, lawyers know what they're getting into. You know, they went to law school, they go to court every day. A lot of us enjoy that stress and that environment. But as far as like the client side of things, litigation can be one of the most stressful things a client ever faces. So I never take it lightly when I suggest that is your final option. I always try to work something out cooperatively with the other side before hitting the nuclear button, which is filing a lawsuit. I always say to clients, that's the last thing you want to do is end up in court, because it's expensive. It's a long process. It's incredibly stressful. So if you can ever compromise and reach a settlement before that, I'm always for it. You know, always start those communications with the other side in a professional, respectful manner, unless the other side has done something so egregiously horrible that you know that they're not going to be reasonable. You're going to get a lot more out of it if you take the softer approach.
Okay, definitely. That's something that makes perfect sense. I've always heard that, courts is one of the most unpleasant things. Now, another topic that I wanted to go over is copyright, because the few times that I have interacted with lawyers within the music industry, it has been because of copyright. I feel like that's one of the first reasons a lot of artists start dipping their toes when it comes to law in the music industry. And I wanted to ask, what do you think is something about people's perspective about copyright that you think should be corrected?
Oh man. Well, first I gotta say that it's completely the right call to think about copyright in the music industry as one and the same, because there is no music industry without copyrights. The idea of ownership, the idea of this recorded music industry was really built off of who owns what and who controls the music. As far as, I'm sorry, what was the main question that you asked, Alvaro?
What do you think is something about people's perspective in copyright that you find yourself correcting them with a lot?
And one of the things that I see all day, every day, and I even encountered this today, is that the idea that whoever pays for a sound recording is the owner, no matter what. And that just isn't true. Under the Copyright Act, it says that whenever you create work, everybody who contributed to that work, whether it's adding lyrics, adding vocals, adding instrumentation, whoever created and ended up in that complete work as a whole is technically a co-author of that work. And without an agreement, everybody that contributes is an equal co-owner. So if there's 4 people that worked on it, everybody's a 25% owner. So this idea that if I pay for the studio time, but I have my friend play guitar, I have somebody sing backup tracks, I have somebody make the beat, whatever, but I still own it, that's just wrong. If you want that, there's nothing wrong with that setup, but you have to make sure that there's a written contract where everybody agrees that that's the setup, and you have to do it through a work for hire agreement.
So, for example, if a label gave me money to make an album, that doesn't necessarily make them the owner of the album.
Yeah, it's not just the money, and a label won't. And that's a perfect example. The recording contract is what gives them the right, not them writing the check. If they just wrote you a check, but they never had this agreement with you, you're still probably going to be the owner if you're the only one creating the work. Where it comes into play is this label, in exchange for them paying for your studio time, wants to own that sound recording. So what you're going to do is say, in exchange for this advance and for this recording budget, I'm going to give you those masters as a work made for hire.
And definitely, that's something that I had no clue about, or honestly haven't thought about that much, honestly. And there's one thing that we agreed to talk about that I think is very interesting, which you said it as, how can I tell the difference in between what's a good deal and what's a bad deal? In the more general terms, how would you answer that question?
I mean, the first thing that I always look for is this deal even legitimate? There are so many scammers out there online, right? Every single day, there's people going through Instagram DMs, reaching out to young, unsigned talent saying, hey, I work with Sony, I work with Universal, I want to give you this record deal. Just pay me $500 for the paperwork fee and we'll send you $1 million. Like, that just doesn't happen. That's not how the labels operate, but it happens every single day. So that's obviously a fake deal, is the worst type of deal. Moving on from that, like what a bad deal is. First, I look at, who are these people? How legitimate is this company? If it is a legitimate operation, they're not scammers, I want to check some references, kind of put on your job application hat. When you are looking to hire an employee, you're asking around for some references. You're looking at their resume. You're seeing what they've done to see if they're going to be a good fit in your organization. That should also be the case with anybody you work with in the music industry. If you're looking for a new manager, a new publisher, you're looking for a booking agent, you don't want to work with somebody that just wants to try this out but doesn't have any track record. You want to work with somebody that knows what they're doing, that has other clients, the other clients like working with them, and they can actually bring you to the next place in your career. So check that out, and the good ways of checking that, obviously do some online research, make sure that they've got a professional website, they've got a professional email, check if they've got a roster, reach out to the people on their roster, see how they like working with them. If everybody says, man, signing with that management company was the worst thing I ever did for my music career, guess what? Don't sign that deal. And then what a good deal looks like is, the more and more connected those companies might be, the better references you have, the more successes they might have on their roster. That looks like a better deal. It's not always the case, though. I mean, I've certainly seen people sign to really, really high-end management deals, and they're working with somebody who manages, Grammy-nominated artist X, Y, and Z. But that manager doesn't have time for the baby artist on their label or on their roster because they're not the one making all the money. So you got to kind of put that in perspective too. But the better deals are going to be ones that conform to industry standards. If it's a management deal, it's going to be a deal that doesn't try to charge some outrageous percentage. A management deal should be between 10 and 20%. If there's a manager who's trying to charge 50%, that's a bad deal. A producer deal, if a producer is asking, if it's a true independent artist and they're asking for more than 50% of the splits, that's bad. If it's a major label deal and the managers and the producers trying to ask for more than 5% of the back end royalty, that's kind of outside of the standard of the industry. So also look at what those standard percentages are, because that's where people can also really try to take advantage of younger artists that don't know what those percentages should be.
That's very interesting. I just remember a story right now that you're mentioning, doing the research in the companies. It was a couple of months ago. I was in Chicago. I was offered a job interview for a label, and I was like, hey, let's go check it out. And I was in the Uber on the way there, and I started researching them on my phone. The label didn't exist. I don't know what kind of scam this was. It's like they created a fake website, a fake LinkedIn stuff. I don't know what kind of scam I was about to fall into, but people will go out of their ways to scam you. I mean, scamming gives a lot of money, for sure. There's another thing I want to talk about that I've heard that can really hurt a lot of artists, which is exclusivity clauses within contracts. I've straight up seen artists, stories of artists that, they sign up with a label, and the label, if you play live, it's because we make you play live. If you release music, it's because we make you release music. And then what ends up happening is they sign in the label, and the label does nothing, basically freezing the band. I've seen things as extreme as that. But what is your take when it comes to exclusivity clauses in contracts?
So there's plenty of legitimate reasons for exclusivity. Think about it in the publishing administration world or the publishing world. Two different companies can't be going out there and trying to collect the same ASCAP BMI royalty stream. Only one. They've got to be the exclusive one. In the recording industry, exclusivity is important because this label's investing in you, and they don't want some other label to also be releasing a competitive release that also features you. And now kind of the more money they spend on you, the more money they have to outbid the other release that you did. So there's some real legitimacy to exclusivity. Now, where it might not be as beneficial is in the live touring world. You can see non-exclusive contracts where maybe a live booking agent will just do your festival gigs, or will just do your college booking gigs, but anything else, or especially things that you get yourself, they don't touch that. I think that's completely fair. That's completely reasonable. But as far as exclusivity and the idea of potentially being shelved, those are a little bit different things. The worst place that an artist can be is signed to a label that doesn't want to release their music, but doesn't want to let them go. And that is just no man's land. No other label can touch you because this label has locked you down, but they don't like you enough to put out your music. So when I negotiate record label contracts, I always make sure that there's a guaranteed release clause, also known as an anti-shelving clause. This doesn't actually guarantee that they release this record, because they might not like this record. But what it does mean is if they don't release the record, you get to walk out the door.
So that's very interesting. Another thing I want to go is maybe you have any particular stories or case studies of predatory clauses within contracts, maybe hidden, maybe not so hidden, and people just don't realize how dangerous these are. Do you have any examples of these?
Yeah, one of the ones that I think about often is the idea of this evergreen clause. And that is related to the term or the length of a contract. And an evergreen contract is one that automatically renews at the end of that current period. So say you sign a 1-year deal, and always make sure that you check at how they define that term, because it could be 1 year and then it's 1 year and it's ending and you're done and everybody's gone. But more likely than not, it might be 1 year, and that's going to automatically renew unless you or the other side gives notice within a certain really small window right before the end. And it could be something like you have to give notice at least 30 days before the end of the term, but no more than 90 days before the end of the term. And you really have to calendar this if you want out. I've seen artists that release a record and they licensed it to the company, and that was a 2-year license, but the term automatically renewed if nobody did anything. So now we're 15 years later, somebody wants to re-release this record. And the artist thinks, yes, we absolutely can do that. That was just a 2-year term. No problem. I own all the masters now. They just had a 2-year license. We look at the contract, not so fast. That contract is still active because we never terminated it. So an evergreen clause is one that you're going to want to limit. You're going to want to put some protections on. There's some legitimate companies that have evergreen clauses like ASCAP and BMI, notorious for having evergreen clauses. And that makes sense because this is kind of a set it and forget it. People really don't leave ASCAP or BMI once they set up with them. But with a label, you are going to release more music. You're going to want to get your rights back. So limit that, or limit the amount of options that they might have. Another thing that's predatory is just how money is defined, how you're going to get paid. The biggest place that record labels and other people hide the money is in the definition of net profits. They say, gross profit is anything that comes through the door. That's all the money. And net is defined in a very broad way as gross money minus expenses. And expenses can further be defined as every little thing the label has ever paid for in connection with your music. So you can imagine if you're making a bunch of money, but the label also paid a bunch of money, $100,000 minus $100,000 in expenses equals 0 net profits. So you're not going to get anything. So be very careful of what is included in those net profits. What I like to say there is that the legitimate, verifiable, actual expenses that were made solely in connection to recording, manufacturing, and releasing this album will be deducted from the gross profits. But I'm not going to give you this huge runway to deduct everything you've ever spent.
Definitely. So that sounds like a very extreme case. Like a label can use kind of funky language when it comes to defining the profits to make it so you get nothing.
It's known as Hollywood accounting, and it's even worse in the film industry. You think about actors who get like back-end royalty participation. Most actors don't see those royalties because there's never any profits because of the way that they very meticulously draft those expenses.
Okay, definitely. There's one question I want to finish off this interview with, which I want to ask this question to every expert I meet within the music industry, is I am an artist. I am the single most scammable person in the world. Artists like myself, we're very passionate. We can be very naive, and I have been naive. And the question is, from your expertise, how can I avoid being taken advantage of?
That is a great question. The artist is absolutely the easiest target for a scam. And I'll tell you why. It's not because they're not smart. It's not because they're not thinking right. It's because they are so focused on their art and they're told every single day no, that when somebody says yes, they get very excited. Something's happening. Somebody believes in me. And that can cloud your judgment for right or for wrong. Don't beat yourself up over it. There's some very, very sophisticated scams where people will go on and they will clone an official website. They will mask their caller ID so it actually says that it's coming from Sony. They'll do a lot of different things to look very legitimate. But if you're an artist, think about the TV show Catfish, and you've got to play that game. If somebody's reaching out to you via Instagram, have them send you an email. This is the best first trick to make sure that you're not getting scammed. Take a look at that email address. If they're actually somebody at Sony or whatever company, Universal, it's not going to be, James Smith, Sony CEO at yahoo.com. It's going to be J Smith at Sony, J Smith at umg.com. Look at that email address itself. That is going to be the biggest dead giveaway of a scam. Then look at that email. Yeah. Is it well drafted? Are there a lot of typos? Is the spacing really weird? Is there words that they don't quite say right? This might be scammers in another country after all. And then if there's phone numbers listed in that email or in that contract, call those phone numbers. They could be fake phone numbers, and they might just, hit to a dial tone or like the text to number subscriber you can't be reached or something like that. Dead giveaway. Then, if they're asking for any type of money, also dead giveaway. If this is a legitimate offer, they should be able to have the contracts already written because they offer deals every single day. They've got a legal department. They don't need you to pay $500 so that their staff attorney can put together this form agreement that they put together every single day. And if they ask for any type of personal information, you should be very, very wary of that. If they want you to provide your social security number, picture of your driver's license, anything like that. So just to recap, the scam looks like this. Look at the email address. If that email address isn't from the actual company and their domain name, more likely than not a scam. Look at the typos, look at that phone number, give that a call. And then finally, once they send you that contract, look at what that contract says. More often than not, those scam contracts, they're not even going to bother putting in your name, putting in the date, today's date, and whatever. They're just going to have this fake scam contract that says Sony, artist blank, fill in here, date blank, fill in here. They haven't even customized it to you.
That's a whole bunch of stuff I didn't consider. I mean, it makes perfect sense. The checking the domain, straight up calling them, all that kind of stuff. And I was once recently almost scammed, and it was like a long time into, like, I didn't give any money away, luckily, but it was a while into the scam that I realized, oh my god, that's not legit. Like, this guy dedicated so many hours of their life to scamming me, and I haven't even given them anything yet. That's something amazing that you mentioned. I was going to ask you at the end of the interview to recommend this content, or maybe a video or something where you think somebody could learn about law. But the first one I'm going to mention is your Instagram page. You're constantly posting some very nice advice there, so we'll obviously link it somewhere in the description if you want to say it straight up, so people can look it up as well.
Yeah, absolutely. So like you said in the beginning, I'm Ryan Schmidt. I'm a music lawyer here in Savannah, Georgia. I'm a partner at Bowen Schmidt Entertainment Attorneys, and my Instagram is at ryanschmidt.esq.
Okay, amazing. So thank you so much, and let's hope this happens again.
Yeah, absolutely. Thanks for having me. Enjoyed it.
Okay, thanks.